thank you for agreeing to talk with us like this. We really appreciate it. And so my first question I would like to ask is, you talked about the need to humanize justice and the justice system, and I would be so interested to hear more about what you mean by that and what you could imagine that would look like.
When we talk about access to justice for people with various types of disabilities, we very often forget about the atmosphere, the power relations in the room, in the courtroom. And I think that for people with psychosocial disabilities and intellectual disabilities, also people with various forms of autism, one of the highest barriers to fully and fairly participate in any process by the justice system comes from the fact that even non-disabled people very often find highly uncomfortable when they have to enter a courtroom, they have to participate in the process. In the center of the courtroom, there is the judge, with all the power of justice, and the status of all others is subordinated to this. These power hierarchies are very rigid. They often act against enabling, for instance, the victim or a witness or the accused to feel equal right to participate, to feel that the process is fair, and the goal of the process is nothing else but justice. We mustn't forget that what has power is justice, and not the symbols, the symbolic powers in the courtroom. And when I'm talking about humanization of justice, I primarily mean that all people who are involved in a particular case, in a particular process, are humans who have a common goal, namely to finding out all the circumstances which are relevant in order to come out with the just solution. And I am very much convinced that this humanization of justice is good not only for people with disabilities, but for all people who are involved in any justice process.
Thank you. I can understand that, yeah. What do you think people with disabilities would need in order for the justice system to be more human for them?
Yeah, and I think that this question brings us to the difficulties. Because if you ask judges, if you ask prosecutors, any actors in the justice system, I think that they will all agree with what I have said about humanization of justice. The real difficulty comes from the how question. How can this be realized? Especially because we talk about very formalized processes. And when I'm saying that justice is a very formalized thing, I don't judge it, I don't give a value to it. I think there is a practical reason why it is formalized. If we believe that people are more or less similar, then fairness is not very far away from formalization. If something is fair for one, we assume that it is going to be fair for the other as well. Now, this is what isn't true for most people with disabilities. People with disabilities have a lot of needs which cannot be made uniform. Especially when we talk about people with psychosocial disabilities and intellectual disabilities. The needs can be very individual. And this is, I think, what makes humanization of justice for people with disabilities difficult. You have some principles which are universal, but the realization of those principles should be very individually tailored. For people who have communicational difficulties, evidently anything which can help the person with a disability to communicate well and efficiently is important. It can be a personal assistant, it can be a support person, it can be the use of non-verbal communication, it can be a wide range of various things. And indeed, when the judge wants to explore and determine what sort of accommodation this particular individual with disability requires for the process to be fair and equal, then needs to consult other experts who are familiar with the person with disability, their needs, and also with some professional knowledge on communication, on behavioral patterns, and so on. Now, when we come to other areas than communication itself, behavior is another factor which can result in barriers, in image barriers. People with psychosocial disabilities, people with autism in particular, but also people with intellectual disabilities, can have behaviors which are different from the so-called average, whatever it means. And this should be taken into account. So, for instance, behavioral patterns which would suggest for a judge that a non-disabled person is not necessarily telling the truth, because the way how the person communicates doesn't seem to be consistent with, for instance, the body language, with the emotional expressions, etc., etc. And again, this needs to be balanced, this needs to be taken into consideration, and this obviously may require skills which are not expected to be a good judge's skills. It may go beyond that. That is why it is really important to include professionals who will help the process.
Thank you. Yes, I understand what you mean about the kind of range of accommodations that are really necessary for people to be able to access justice at all.
And if I may add what the Convention on the Rights of Persons with Disabilities says about it, the Convention uses the term accommodation. The person has a right for accommodation and doesn't use the term which in other articles in the Convention is used. It doesn't mention reasonable accommodation. It says accommodation. Now, why is the difference? I think, and this was how the Committee on the Rights of Persons with Disabilities understood it when I was a member of the committee, that accommodation means more than reasonable accommodation. There is no qualifier in the case of access to justice, because what may be otherwise beyond the limits of reasonability still may be required for a fair justice process.
What is the difference more between a reasonable accommodation and an accommodation that is required for somebody to access justice?
But it's I think, quite sophisticated. But in my simplified understanding, the essence of the difference is the following. When we talk about reasonable accommodation, then we have some more or less shared understanding of what undue burden means and the limit for the requirement of accommodation is that undue burden. It can be resources, it can be procedure, it can be anything which go beyond what I currently understand as reasonable. Now, when I mean accommodation in the sense of access to justice, then I expect more aspiration to accommodate the needs of people with disabilities.
Two of the other big barriers that people with disabilities experience to access justice are their legal capacity and the lack of recognition in many places of legal capacity, and their credibility as a witness or as a victim. I wonder if you could say something about those two areas.
Legal capacity and the way how the Convention conceptualizes legal capacity is crucial to access to justice. In a sense, I think we can say that access to justice is a particular aspect or component of legal capacity, or the exercise of being equal part of any justice process, equal to non-disabled people. Requires that the person with disabilities' legal capacity is recognized on an equal basis with others, and also means that the support the person requires to exercise his or her legal capacity is provided. So the fact that a person requires some support to act competently, that is to exercise their legal capacity, shall never suggest that the person lacks legal capacity. And again, there is a very common misunderstanding, namely that people confuse mental capacity and legal capacity. The Convention doesn't say anything about mental capacity, which had been in the focus of the discourse about people with disabilities who lack capacity, who are not competent because of their mental condition. Let it be an intellectual impairment, or let it be a psychosocial difference. Legal capacity is a fiction which society guarantees to all adults in our societies, except some exceptions, including persons with certain types of disabilities. Now, the Convention recognized that this different treatment of people based on their mental capacity translated into legal capacity is not just, and it is not justified. And the way out is in support to the exercise of legal capacity. So the presumption is that whenever a person with disability is limited in their exercise of the legal capacity, it is not because the person does not have that capacity. It simply means that the person needs something to effectively exercise their existing capacity. The second part of the question was credibility. I think credibility is closely connected to the recognition of legal capacity. And very often, the mistrust in the person's credibility comes from the fact that we presume that the person lacks capacity. Or it may come from what I already said before, in their different behaviors, different ways of communication, different ways of their expression of emotions, and the like. It's really important to be very cautious, and the judge, the prosecutor, whoever participates in the process should really reflect whether they give the same quantity and quality of credibility to persons with disabilities as they would give to a non-disabled person.
Yeah, thank you. That makes a lot of sense from what we found in our research, and how many people are not taken seriously when they report a crime, or it also leads to certain treatment of the person, that maybe even medical treatment, when what has actually happened is a criminal act and they get treated for a medical condition. So yeah, it's absolutely fundamental that their capacity is recognised.
So I think a critical component of justice is the restoration of the victim's integrity, moral integrity. In case of a violent, physically violent crime, also the person's physical integrity to the extent possible. And the process of coming to justice is an integral component of justice itself. So if the victim is taken seriously, if the victim can experience that they were taken equally in the process, and the imbalance which was caused by the criminal offense in which they became victims is compensated. I think for me, justice primarily means this. I think it can be a severe further traumatization. So the victim was a victim in the criminal offense in the first place, and now the person becomes the victim of an unfair process in which he or she cannot realize their desire for that sort of a compensation I spoke about. And this double or multiple traumatization is very harmful because the person will lose trust not only in the justice system, but exactly because of the power, both the real power, the material power, and the symbolic power the justice system has in our societies. Their powerlessness becomes, I would say, almost unlimited, and may lose trust in society as such, any kind of formalized structure in society. And I think that if we take this in mind, then this will help the system to actively and proactively seek for all the accommodations which are possible and the humanization of the ways how they operate when they have to move away from business as usual. And in the end of the day, I think that this humanization of justice is helpful for all people who are involved, not only people with disabilities, because it will help to raise a new culture of justice.